Most people believe that jury selection is a random, neutral process designed to find the most fair and impartial people possible. That belief is almost entirely wrong. In reality, jury selection is one of the most strategically calculated phases of an entire trial, and both sides are working hard to seat the jury most likely to rule in their favor. The truth about what happens in that courtroom before a single piece of evidence is shown will fundamentally change how you think about the American justice system. In the next 10 minutes, you will learn exactly how the jury selection process unfolds from start to finish, what both attorneys are actually trying to accomplish, and why the system that is supposed to guarantee fairness is actually a high-stakes psychological competition. We will walk through the mechanics, the legal framework, the hidden strategies, and the real-world examples that expose how dramatically a jury can be shaped before the trial even begins. And the most counterintuitive insight is coming up after the background section, so stay with us. Background jury selection in the United States traces its roots back to English common law, which the American founders largely adopted after independence. The Sixth Amendment to the Constitution guarantees the right to a trial by an impartial jury in all criminal prosecutions. The Seventh Amendment extends that right to civil cases involving more than $20 in controversy. These are foundational protections, but neither amendment defines what an impartial jury actually looks like or how you find one. The formal process of assembling a jury is called voir dire, a phrase borrowed from Old French that roughly translates to speak the truth. During voir dire, prospective jurors, known as the jury pool or venire, are questioned by the judge, the prosecution, and the defense. The stated purpose is to identify and remove anyone who cannot be fair and impartial. In practice, it is far more complicated than that. The modern jury system has evolved significantly over the past century. Before the mid-20th century, juries in many parts of the country were almost exclusively white and predominantly male. A series of landmark Supreme Court decisions gradually dismantled the most overt forms of discriminatory jury selection. Batson v. Kentucky in 1986 is perhaps the most significant. The court ruled that prosecutors cannot use their discretionary challenges to remove jurors solely based on race. This ruling was later extended to gender and other protected characteristics. But even with those protections in place, the strategic manipulation of jury composition continues through entirely legal means, and that is where things get genuinely fascinating. Main content: every jury selection process begins with summoning citizens to court. Jury pools are typically assembled from voter registration lists, driver's license records, and other government databases. Once potential jurors arrive, they fill out questionnaires covering their background, employment, prior legal experience, and any potential biases. In high-profile cases, these questionnaires can run dozens of pages long. Then comes the actual voir dire questioning. The judge usually goes first, asking general questions to screen for obvious conflicts of interest. Then the attorneys get their turn. And this is where strategy takes over completely. Each side has two types of challenges they can use to remove potential jurors. The first is a challenge for cause. This means an attorney has a specific, articulable reason why a juror cannot be impartial, such as knowing one of the parties, having already formed a strong opinion about the case, or having a financial stake in the outcome. There is no limit on challenges for cause. If the judge agrees the reason is valid, the juror is dismissed. The second type is far more powerful and far more controversial. It is called a peremptory challenge. With a peremptory challenge, an attorney can remove a juror without giving any reason at all. Federal criminal trials typically give each side between 3 and 20 peremptory challenges depending on the severity of the charges. Civil trials often allow fewer. State rules vary widely. Here is what nobody talks about. Peremptory challenges have become one of the primary tools through which experienced trial attorneys and their jury consultants engineer the composition of a jury entirely within the rules of the system. This is where the real strategy lives. Prosecutors often use peremptory challenges to remove jurors who appear sympathetic to defendants, who have had negative experiences with law enforcement, or who belong to demographic groups statistically more skeptical of government prosecution. Defense attorneys do the exact opposite. They target jurors who appear rigid, rule-following, or particularly sympathetic to law enforcement and authority figures. The use of professional jury consultants has grown dramatically since the 1970s. These are social scientists, psychologists, and communications specialists hired to help attorneys identify ideal and unfavorable juror profiles. High-profile cases like the O.J. Simpson criminal trial in 1995 made jury consulting a household concept. Simpson's defense team reportedly paid millions for jury consulting services, and the racial and demographic composition of that jury became one of the most analyzed in American legal history. Modern jury consultants use shadow juries, focus groups, and mock trials to test how different types of people respond to evidence and legal arguments. They analyze body language during voir dire to identify jurors who might be hiding biases. Some firms use social media research to build detailed profiles of individual potential jurors. The line between thorough preparation and invasive profiling is genuinely blurry, and the law has not fully caught up. Deep Dive: The Batson Challenge, which arose from that 1986 Supreme Court ruling, is supposed to prevent racial discrimination in jury selection. Here is how it actually works in practice. If one attorney believes the opposing side is using peremptory challenges to discriminate based on race or gender, they can raise a Batson objection. The judge then asks the challenging attorney to provide a race-neutral explanation for the dismissal. The attorney offers an explanation, the judge decides whether it is credible, and the process moves on. In practice, Batson challenges are notoriously difficult to win. Attorneys can almost always produce a surface-level neutral explanation, and judges rarely overturn peremptory challenges. Studies have consistently shown that racial disparities in jury selection persist decades after Batson. A 2010 report by the Equal Justice Initiative found that in several southern states, prosecutors struck black potential jurors at more than double the rate they struck white potential jurors. What does this mean for the concept of a jury of your peers? That phrase, while popular, does not actually appear in the Constitution. What the Sixth Amendment requires is an impartial jury drawn from the district where the crime occurred. Courts have interpreted this to mean a fair cross-section of the community must be represented in the jury pool, but not necessarily in the seated jury itself. That distinction carries enormous consequences. There is also a growing body of research on how juror psychology shapes verdicts entirely independent of the evidence. Studies show that jurors frequently make up their minds early in a trial and then selectively process subsequent information to confirm their initial impressions. This is called confirmation bias, and experienced trial attorneys know it well. The goal during jury selection is not just to remove unfavorable jurors but to seat those whose existing worldview already aligns with your narrative. Analysis: the implications of all this extend well beyond any individual trial. If jury composition can be systematically shaped through legal strategy, then the outcome of a trial is never purely a function of the facts and the law. It is also a function of resources. A wealthy defendant or a well-funded prosecutor can hire consultants, conduct extensive research, and execute a far more sophisticated jury selection strategy than a defendant relying on an overworked public defender. This raises serious questions about equal justice under the law, the phrase literally carved above the entrance to the United States Supreme Court. Several states have already moved to limit or eliminate peremptory challenges entirely. Arizona eliminated them in 2021, becoming the first state to do so. Advocates argue this is a necessary step toward genuinely impartial juries. Critics worry it removes a safeguard that helps both sides ensure basic fairness. Jury selection reform is now a serious topic in academic legal circles and among civil rights organizations. The conversation is no longer just about how to make the system work better within its current framework. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.